Hi everyone, welcome to School Slow. Salamatu again, and today we are going to be talking about breach of the duty of care under the law of tort. This is School's law, and all we do is teach the law. In our previous videos, we tried to establish what we mean by duty of care and who a person owes it to. So today we are going to be talking about breach of duty. When can we say that a person who owed a duty of care has breached that duty? The test for determining whether or not a duty has been breached is that of the reasonable man, i.e., what would the reasonable man have done under the circumstances? The courts allow themselves to be guided by some 5 principles in determining whether there has been a breach of duty. The first one is that they consider the likelihood or the foreseeability of the harm. The more likely it was that harm was going to occasion out of a person's actions, the more likely the court would hold that there has been a breach of a duty of care. In other words, if the harm was foreseeable, then the court would presume that the reasonable man would have taken that into consideration and would have been guided by that in doing the action in question or the negligent conduct in question. And in Bolton versus Stone, Lord Potter puts it this way. He says that in determining whether there has been a breach of a duty of care, we are not only concerned with the foreseeability of the act, but we are also concerned with the foreseeability of injury resulting out of that act. So like I said, the more likely it is that injury would have occasioned out of that conduct, the more the courts are likely to hold that there has been a breach of a duty of care. The second thing the courts consider is the magnitude or seriousness of the risk. So if the injury that is likely to result is going to be grave, the courts are likely to hold that you've breached your duty of care, because if the injury is grave, then the presumption is that the reasonable man would have taken that into consideration in doing whatever conduct that is being challenged. An important case that illustrates this principle is a case called Paris versus Stepney Borough Council, in which case a man was employed to work on a lawn. The man only had one eye. He wasn't given goggles by his employers. In the course of work, he encountered injury in the only eye he had, and then the injury resulted in him losing that eye, so he became totally blind. He sued his employers for breach of duty of care to have provided him with goggles to protect the only eye he had, and the action was successful because the courts reasoned that even though the employers didn't usually give their employees goggles, in this particular circumstance, this man in question or this employee in question had just one eye. So if there was injury to that one eye, it was going to be grave because he would lose his sight completely. So the court thought that having regard to the magnitude of the risk that was likely to have happened in case of them not providing him with goggles, we should have, in consideration of that, giving him goggles. The third thing the court consider is the importance or social value of the activity being done. In this case, how important is the activity? An activity may be risky, it may be harmful, but then because of its importance to society, we cannot entirely hold that doing it amounts to a breach of a duty of care because of its value. A case that illustrates this is the case of Watts versus Hertfordshire Council, in which case there had been an accident and the council asked one of its employees to go and rescue one of the accident victims who was stuck under a truck. He was supposed to do this by use of a certain machine, and that machine was to be conveyed using a particular vehicle, but the vehicle was not available as at the time. So he used another vehicle which was not appropriate under the circumstances. As a result, when he was conveying the machine to the site of the accident or to the scene of the accident, the machine fell off and injured the claimant. The claimant said that under the circumstances, the council had been negligent or they had breached the duty of care they owed to him as a road user because they allowed their employee to use an inappropriate vehicle in conveying the machine. The court held that if you look at the circumstances of the case, there was an accident victim who needed to be rescued. So even though there had been a breach of a sort in this case, it was not actionable because of the importance of what the employee was being asked to do, i.e. going to rescue an accident victim. The fourth thing the courts take into consideration is the cost involved in averting the risk. the more expensive it is for a person to avert the risk involved in any conduct, the more unlikely the courts are to hold that he has breached a duty of care by being involved in that conduct or being involved in that activity, provided that the person took all reasonable steps within his means to be able to avert the risk. In a case called Latimer versus AET Limited, the defendant's company was flooded. And then as a result of that, the floor became slippery. What they did was that they tried their best to dry it up and then put sawdust at the most frequented parts of the company. And then they also put signs showing that there was a slippery floor and that people should take care. The claimant was an employee of the company who slipped and suffered some injury because he made use of the less frequented parts of the company. And those parts had no sawdust on them. He claimed that his employee owed him a duty of care to have ensured that the entire place was safe for his movement, and that by breaching that duty, they had caused him injury as a result. The courts did not agree with the claimant. In other words, they held for the defendant, saying that under the circumstances, the defendant had done all that was in their power to avert the risk, putting the signs there, putting sawdust at the most frequented parts. The only solution that would have prevented the injury from the claimant was if they shut down. And that was too high a price to pay in order to avert a potential risk. In another case, Bolton versus Stone, a cricket ball flew over the cricket pitch's 17-foot wall and caused injury to the claimant while the claimant was in their house. Now, the court thought that there was no breach of duty under the circumstances because the wall could not go beyond 17 foot. It was unreasonable for you to say that the managers of the cricket pitch should have gone beyond 17 foot when they were making the wall in order to prevent any potential injury to the surrounding houses or the people in the surrounding houses. And the last thing or the last principle the courts take into consideration is whether the person in this case has complied with approved standards required of them in conducting that activity or in doing that activity. So, for example, if you are suing a medical doctor for medical negligence, the question is, did the medical doctor in question comply with all the necessary requirements in conducting that medical activity? If yes, the courts are unlikely to hold that there has been a breach of a duty of care. In Stokes versus GKN, the court held that the courts will be wary in finding that which would have been commonly done by others as amounting to negligence unless it amounts to plain folly, establishing or affirming that the courts are very, very reluctant in finding a person to have breached their duty of care if the person has followed or upheld all the necessary requirements in conducting that kind of activity or in doing that kind of activity. These 5 principles are established under the common law. There may be other guidelines as provided by legislation that would be considered by the courts in holding that there has been a breach of a duty of care. This is where we end today's video.